Chairman Hicks for a chance to address the committee. My name is Dorr with Wyoming Gun Owners. I'm not going to discuss as much what the bill does do. That's been discussed a little bit already. I'm going to discuss what the bill does not do. There's a lot of miscommunication on what this bill actually means. You asked the question, others have mentioned the idea that who decides in a situation where force is used. And the answer to that question is going to be right there on page 2, section 4 through 7. This is going to be, the standard here is defensive force. And so a peace officer's job by default is to determine probable cause, whether it's if I ran a red light or all the way to a use of force situation. They decide, they issue a charge based on their interpretation of the situation. But the point here is that it's based on defensive force. And that is found and identified in the code on page 5. Let me see here. This is going to be lines 9 through lines 15. So the code will address the standard. In other words, the gun owner, the person who uses force, does not make the determination. He doesn't have his own narrative of the facts. The situation is interpreted by the officers in light of the code, which defines reasonable force. If they determine there is no probable cause that force was used, then charges will not be forthcoming. If they believe that force was not defensive based on the code, they would then stand for charges. And so there is an objective standard. It's not based on what I believe or what anybody else believes. It's based on the code, and as the officers interpret the actions in light of that code. You asked the questions, Chairman, about how many states have the enactment clause that we have here on page 3, lines 1 through 9. I can't give you an exact number of how many states have that. What I can tell you is I work a lot also in Iowa, and Iowa passed the standard ground law just last year, 2017, and despite our efforts, there was no enactment clause. So we have a situation right now in Iowa where 2 individuals have availed themselves to a standard ground law situation. One individual, just in the last 10 days, was granted immunity prior to trial. The other, however, was forced to go all the way through trial, was found guilty last week or perhaps 10 days ago, and now begins the immunity question. And the system in Iowa is very confused right now because with no enactment clause, when does this come into play? And so the idea here, the aim here is to make it uniform. This is how it applies. This is when it applies. Because if someone is found immune after the trial, well, we've kind of defeated the purpose because the person has gone through the expense and all the emotional toil and trauma of the criminal action. So the idea here is to learn from the states that have made mistakes in the past when they have passed standard ground law by giving an enactment clause to make it very clear when these things would actually take effect. Chairman, you asked a question about how many states currently have this. I probably can't see it here. This is a map currently. This is on Wikipedia. It's not our map. It's not any organization's map. It's just on the wikipedia.com right now that show that I believe it's 35 states that currently have standard ground law. Of that, 27 of them passed it via legislation, and 8 additional ones did so via case law and or jury instructions. At the end of the day, 35 states excuse me, have this law on the books. As you can see from the map here, no state north, no state south, and no state west of Wyoming doesn't already have these protections on the books. Some have said, Chairman, that this bill would negatively impact minorities. And the truth is, it's exactly the opposite that is the case with standard ground law. The Cato Institute did a study on this recently that showed that it's minorities that benefit the most from a standard ground law situation. The situation Senator Bouchard referred to in Iowa involved an African-American individual who used his firearm and did so in a self-defense situation. And had it not, and he was found innocent eventually. But as you heard, he spent 112 days in jail, and he emerged destitute, bankrupt, homeless, jobless, and living in his car. And so, had we had the protection in place, it would have protected him as would any other individual back at that time. Some have made the allegation, you might hear it yet today, that shooting victims excuse me, cannot get restitution, cannot receive financial compensation because of standard ground law, but that's it's just not possible because the code is very clear. It's going to be on page 3, lines 18 through 22, that the only person who would not be able to go to civil action would be somebody who perpetrated the crime. In other words, if I break the code, if I am found guilty in court of violation Wyoming's offensive statutes, I can certainly face a civil action. But if I did not break the code, and if I acted reasonably under the code, then the person I shot was not a victim. Rather, I was the victim of the crime, and I was forced to use my firearm to defend my family and myself and my loved ones from the attack. So the idea that a shooting victim can't receive compensation is just, it's not, that person can't be the victim, by the way that the bill has been drafted. I won't belabor the point, sir.
We need to wrap it up.
I'll stop right now and stand by for any questions.
Yes, sir. Anybody on the committee, any questions? Here, I'm good. Go ahead, Senator Dorr.
Thanks, Mr. Aaron, going through the code there on page 6, line 22 and 3, I think the standard is that the person reasonably believed that force was necessary to prevent death or serious bodily injury to himself or another. That seems like a fairly low bar. I don't know if there's some other verbiage in there that might be a little more descriptive than the person that defended himself reasonably believed. And is something more descriptive than reasonably believed that people could tie themselves around a little bit better? Have you seen anything out there in any of the other statutes?
Well, Mr. Chair, members of the committee, I think the idea here is based on the reasonable man doctrine, reasonable man standard that's been around since the English common law era. And it's just the idea that the question is not what do I think, and what does 12 reasonable other individuals think about the situation that happened in this matter. And so it's trying to, again, make it not in the mind of the beholder, but rather what do 12 other reasonable individuals, in this case a jury, for example, believe about this. And so that's been kind of a common law standard for a very, very long time. That's perhaps the best way I can answer your question. And I would point out specifically again, though, on page 5, this is going to be more in the area of lines 11 through 15. That's where we're specifically defining, what type of force, it's that force that others in like circumstances would judge to be necessary to prevent an injury or loss, and no more force to prevent, I lost my spot here, and can include deadly force if necessary to prevent death or serious bodily injury to himself or others. And so that is the standard, and it's very clear that it's no more force than necessary. So if somebody punches you in the face, you cannot draw your firearm and then try to claim this is a standard ground law situation. That's not going to meet the standard in this bill. And again, just so we're on the same page, the bill clearly states that it only applies if you're not engaged in criminal activity. So nobody could use this in any kind of a situation to defend their criminal actions. You, by statute, here cannot be engaged in criminal activity.
Mr. Chairman, I'm getting a little more confused now when you said that the reasonable standard is 12 jury men determining what is reasonable, because we've got places in the bill that necessarily leave it up to a judge, who's not a jury. And so to determine the reasonable standard. So it might be instructive to me that at some point in time you could write down your thoughts so we have a clear understanding of them, because I think we're getting mixed signals about the direction the bill should go from one of its components from what the actual language is in the bill. I wanted to be clear.
Okay.
Thank you, Mr. Chair.
Yeah, any other questions for Aaron? Senator Barnes.
Mr. Chairman, Aaron, how does the person know, if you said somebody hits you, how do you know that person is going to hit you one time or 10 times? And how do you know, in my own experience, I know 2 people, one of them was killed by a single hit. He died, and I know another person who hit the guy and killed him. One blow. So when does reasonable force start? After 5 blows? Or is it just in your arms? Or once they go to your head, then you can shoot your gun?
Mr. Chair, members, yes, that's a good question, Senator, and that's why we don't list off a line item issue of when this force applies. It's based on this reasonable standard, because you're right, sir. One blow, from somebody my size might be sufficient to kill you with one blow. Whereas if you were to strike, someone my size, it would be inappropriate, obviously, to respond with force. And there is no one catch-all definition. It's based on kind of a disparity of force that peace officers use to decide. It's the case of, one person versus 5, or a woman versus a man, or 2 men, one weighing 100 pounds, one weighing 300 pounds. That's going to be up to the peace officers to decide based on that probable cause. And those issues are very much part of their training to decide what constitutes that deadly force.
Aaron, a comment, and it takes off from when Senator Myers, and I'll just tell you that I have some concerns. When we go to page 3, and we get to line 6, lot 5 and 6, it says, "On the filing of a motion, the court shall hold a hearing prior to the trial." So let me define what my concerns are. We have a system in this country that's trial by jury and trial by your peers, and quite frankly, I think this starts to instill too much power into the judicial branch and eliminates that potential opportunity for trial by jury. I've got some concerns that this may have some negative ramifications both ways by turning this initial hearing just over to a judge. I think that's a little bit problematic. And so you understand what I'm saying, is it could go both ways. And again, I think anything that goes to a trial of your peers has a much higher likelihood that justice will be served than if we just single out somebody from the judicial branch, given their individual biases. We're all people, judges have biases, both pro and con. So I think you run some inherent risk, whether you're either for it or against it. My concern is that it may influence the outcome of the judicial hearing, or you only have that. So I just illustrate that's an area that I have concern. I just don't think it gets us to, my understanding of this is the legal process in a situation like this, where you may have a death involved. I'm much more comfortable with the jury than I am the judge. I hope you understand that.
Yes.
Do you have any response to that?
Yes, Mr. Chair, I think the idea here that's being sought after is trying to decide, if a person uses this force, are we going to, again, using the situation in Iowa, even though justice was served, the individual was found not guilty, he's a broken man, and more or less, if he recovers from this financially, it might take him a very, very long time. And the protection here is simply that if the idea is that there was no violation of the defensive force statute, that we don't want to unnecessarily put somebody through a situation where justice was served, to use the expression used in Iowa, but I emerge bankrupt and I emerge destitute, unemployed, homeless, as was the case here, because that's oftentimes what we've seen. In other words, the abuse, or not the abuse, but the result oftentimes, when it comes to erring on which side of the situation, oftentimes the harm comes from the example I am providing, where the person goes through the whole process and it is extremely difficult on him, even though he is eventually found not guilty. And we're trying to be careful with that here.
Let me follow up with that. So, and I understand that there's remedies for that with the reimbursement, and coming back through that later places in the bill. But let me run a scenario. So you have a situation, somebody claims, understand the ground that they reasonably believe that they were protecting their life. You have to go before the court now. You're going to file a motion and you're going to get a hearing. And you have to lay out all the reasons why this is an affirmative defense of standing. Now here's where my concern comes in. You've just laid out your whole case to a judge. And what happens now if that judge says, no, it's not an affirmative defense, back in the camp? That jeopardizes the ability for that individual to then go to the court and make a defense. It's already been played out now. I think it prejudices the jury in those scenarios. So I think this has the potential to be very dangerous within a court of law, where both somebody was either found not, found that it was defensible, reasonable person, and those that are not. So I think it's a provision that we need to take very cautiously. And so that's my thoughts. You know, we're gonna work this, we got some pretty smart attorneys, not that I put all my faith in attorneys, that put more faith in common sense in the legal profession as a whole, but Senator Myers.
Mr. Chairman, you know, I've been through a few civil lawsuits, and I think that there were a lot of motions that were made essentially by the judge in determining facts and setting aside boards before the jury even saw them. The jury makes the final determination of facts, but how the lawsuits played out, the judge in the preliminary settings of it has a lot to do how the rules are played. And I think that in this particular case, they're really looking at how the rules are played. I think in this particular area, the biggest thing in these sections, and then I think the section above, is having a good idea of the burden of proof, where in line 15 it's clear and convincing. And in another area, it's another standard. And I think would be really beneficial to the committee if we could get a Black's Law definition or whatever term we could of all the different standards that are associated in the bill and anything that's proposed. So we have a good idea about what those standards are. But I guess I'd have to, I don't share the angst that you do as far as having a judge make a preliminary ruling as to whether or not it was a stand your ground. Because if you go in any other circumstance where I think the juries know, any jury knows that there's some degree of evidence that's present if somebody's, you know, sitting in that box, you know, so, and that's, and I think they just look at the facts that are presented. So, I don't have an angst issue on that.
Any more questions? Thank you, Aaron. Next witness,